Hello, my wonderful people. I trust you are doing very well. So, thank you very much for spending time. Again, thank you very much for spending time with us. And we really appreciate all the comments and all the feedback that we get. If this is your very first time here, kindly do us the honors, subscribe to our channel so that you will get all the latest videos that we share for your benefit for free. If you have any question, you can always, send us a message. If there's a topic you want us to discuss, why not? We would get into it for you. So today we are doing part 2 of natural justice. So if you haven't listened to the other session on natural justice, kindly, do that just so that you don't miss anything. So today we are talking about the Audi, alteram, partem rule. So let me quickly just get to that. I've already talked about Audi, Nemo Judex in course as well, so I would not want to waste time on that. But if you haven't listened to that, I would really encourage you that you jump into that one before starting it, just so that you will get the introduction of what natural justice is, all the explanation that I provided before getting to this bit. Good. So in the Audi Outram partem rule, all that we are saying is that a decision to be made by a body will definitely affect the rights or interests or expectations of a person. So if a disciplinary committee is set and they're about making a decision, if it's in the University of Ghana, like where I belong and a proud one, definitely you know that the decision of the disciplinary committee would affect your status in the school. If it is, in the workplace um, where I am, you just know that whatever disciplinary, committee decision that comes at the end of the day would affect the work that you do. So the idea is that make sure that you exhaust all possible options in hearing the other party before you make a decision. So here the rule simply is saying that before you condemn someone, make sure you have heard the defense. Make sure that you have allowed the person to tell you, quote and unquote, all the foolish reasons why he or she may have done that. Because once you try to understand the quote and unquote, all the foolish reasons, you would then be in the shoes to really assess what the person and to know whether the person is actually guilty or not. By not listening to the person, you are, you know, um, you're not giving the person the opportunity to vindicate himself and to also provide a reason for doing what the person did. I mean, you'll be surprised. However heinous and active, there's always a reason behind it. Of course, at times some of the reason may not make sense. That is acceptable, but there are times where if you understand what the person says, you would know that well, the person may be guilty, but the punishment to be meted does not warrant what or it's not in on the same measure as what the person did. So it's always important as a decision maker or as a head of a panel, as a head of a committee or commission of inquiry or what have you, to ensure that the other party is heard. So where the other party is not heard and the committee hastily goes ahead in making a decision, the other party, the condemned party, now has the right to set aside that decision on grounds that he was not given a fair hearing. He was not given the opportunity to be heard, because it is always very, very important. And when we have already mentioned it, that even in the court it happens. But of course, let me quickly add that there are exceptions to this rule. There are situations where, I mean, if you don't make use of the opportunity afforded you, we cannot wait for you forever. So it applies in the court and then administrative bodies, it applies commissions of inquiry and all that, all the various committees that you can, you know, or you know of, or you've heard of, where there's a committee where they're asking a person to come and tell, his story for a decision to be made. The position has always remained that here, the other side. And I did talk about the case of Adam and Eve in the Bible, where God knew what they had done exactly, but still asked them, Adam, where are you? Adam, where are you? So that is all the Odrem pattern. So let's go into more detailed discussion of it. So the right to be heard, when we are saying that a person must be heard, what we mean is that one, the person must be given reasonable notice of the case. So if University of Ghana and for my folks in the and the other universities, pardon me, but yes, allow me to use University of Ghana. Okay, well let me change it. Let's say if you UPS, I'm a student of university, professional studies, and I may have been involved in a more practice, exams more practice, I should say. And I am given a 1 day notice to show up tomorrow. Definitely, that will be a short notice. That is not, fair hearing. That is not they giving me the right to be here, because within that 1 day, I will not be able to get representation. I will not be able to put my thoughts together. If there are evidence that I need to gather, I will not be able to do that. So the idea is that we need to give the person enough information about the case. So normally in the courts, you have 8 days to enter appearance. Enter appearance really means that you have 8 days to tell the court that I have seen the document and I've received it, and you have 14 days to answer it. So even in the courts, we give you all this time to make sure that before you answer, you are very much aware of it. So no way would it happen that a matter, or someone files a matter in the courts today, you are served tomorrow, and you are asked to appear the next day. No, no. If it happens and you go to court, just have to tell the court that there's short service, and the court would gladly allow you enough time, to prepare. So in the case of ex parte appeal, we are saying that the court explained that the core idea implicit in the natural justice principle of Audi alteram partem was simply that a party ought to have reasonable notice of the case he has to meet, and ought to be given the opportunity to make his statement and explain. So if you don't give the person enough time, the person definitely will not be able to prepare you enough, to give you all the answers that you may need. So this principle is very, very important. So if you've been called before a panel where it's a day's notice or it's a half-day notice, you have the right under this principle. And I'm saying that it is not just applicable to the court, for all administrative bodies or public universities, or normally for private sectors, they will definitely have their employee handbook that may dictate how some of these things are. But even in that, I'm sure the principles of natural justice will be prominently be captured in there. So that is it. The next bit is that you have the rights to make representation, and it falls into the other. So if you are only given a day's notice, how can you make sure that you get a lawyer like myself to get him to come and represent you? So you need enough time. So there should be the adequate notice of the place, so where the meeting will be held, the date of the meeting, the time, so that you can go and then prepare appropriately. So then it falls into the right to legal representation. So on the other one, let me throw more light on the right to make representation. That is, for you to appear, for you to appear before the panel, you need time. You need to know the place, the date, and then the time for you to appear. And it falls in the right to legal representation to that. If you want to be represented by a lawyer, you also need time to retain a lawyer, explain the situation to him, gather evidence if any before they do that. And then you also need adequate time and opportunity to defend yourself. So after you have been heard and you've heard what they are saying, you should be given more time to come and gather enough evidence, or call other witnesses to help defend your case. And you also have the right to cross-examine. So if they bring an invigilator who says he or she saw you, collecting a paper or stretching your hand or stretching your neck, should be given the opportunity to cross-examine such a person to make sure that the person is telling the truth. The whole essence of all this exercise is to ensure that we hear the other person before we condemn him, before we rusticate him from UPSA or University of Ghana or GIMPA or wherever such a case may happen. So it's very, very, very important. So now, however, there are exceptions to it. There are exceptions. Resistance can go up. Okay, good. So there are exceptions to the rules, and these exceptions does not only apply to the Audi alteram partem rule, it also applies to the Nemo Judex in Cosa. So let me repeat, these exceptions cuts through the two main principles that we have talked about. So please note, please note. So the very first bit is that a statutory duty. So where a statutory duty impose a duty on you, you must perform it, even though it would amount to breach of natural justice. So if you are the Vice Chancellor of the University of Ghana and by the course of the or the statutes of the University of Ghana, you are supposed to be a chair of a particular committee, the fact that it may involve your daughter or your wife may be of no consequence because by law, you are the only person allowed to do that. So by statute, you would have to do that, and like so really essentially that is it. I don't want to stretch it. Now statutory duty and necessity always work hand in hand. So there are also times that where by necessary implication you are the only person to do an act and no other person can do it. Like there's no other person to do that particular thing. Like under so you I mean statutory duty and necessity really work hand in hand, because if the law mandates you to do it, means that by statute you have to do it. But if the law does not mention any other person, then it means by necessity you are the only person who can do it. Meaning that if you don't do it, nothing can be done about it. So meaning that there will be a lacuna in there if you don't perform that particular act. So essentially that is what we are saying when it comes to necessity. So these two really, do work hand in hand, necessity and then statutory duty. But there's a slight difference. There's a slight difference. It may not be always that it is a statute that appoints you to do a particular thing. But it could be situations where you are the only person who can do it. And even though by you doing it, it may lead to the likelihood of bias. It will be deemed as an exception. That does not mean that the other party cannot appeal it. They can always appeal it, but it will be up to the court to, measure the duty that you had to do and then how it was performed. Because the fact that you are the only person to do it does not mean that you have to be so biased that we just can't help ourselves. No, that's not what we are saying. But we are just saying that there are times where, just by reason of you relating to the other party will can come and say, no, there's bias. In those situations, we'll say, oh, where's the bias? Is it just because the guy or the lady is related to the other party? But by statute or by necessary implication, he's the only person who can do it. So unless you can really prove that, the bias has actually occurred and it has, or it's led to substantial miscarriage of justice, then we would say that it is an exception under the rules. And then acquiescence. Acquiescence is where you know that this person is exhibiting signs of bias. You don't do anything about it. You keep quiet. You wait till judgment or till a decision is made. Now you come back and you say that, oh, but this guy has a shares in the company. This guy is related to this. No. You would have acquiesced, because if you were not very happy with it, you would have raised it from the onset. But the issue of acquiesce also has to do with time. That is, when did you become aware that this person or the decision maker related to any of the other parties or had an interest in that particular matter. So when it comes to acquiescence, time is very important in determining whether that has happened or not. I think Good. I think this will be the last exception, which is that where you make it impossible to be heard. I think from the ones I may have mentioned or in the other discussion on the Nemo Judas, or I think the introduction on this, where I said that if you are always, evading the court, if you are refusing service, if you are deciding not to show up in court, the court cannot wait for you forever. So if you make it impossible to be served, if the bailiffs are coming to you and you are always running away, you're always hiding in your room, locking yourself when they know you are in there. When your son is saying, my mother is in the room, but you are refusing to come out, then we cannot wait for you. So if you make it impossible to be heard, then again, we just cannot wait for you. So if a decision come, you cannot come and say that you were not heard. Because here it's about being heard, but if you are making it impossible to be heard, then there's very little that we all can do about it. So that is that with the Audi alteram partem rule and the exceptions to natural justice. I think I was a bit fast with this, but I hope it was clear. I hope you understood what I was saying. If there was any confusion somewhere, you can just let me know. I will do a very short video to clarify, or we can just get in touch and then I will help you with that. So again, thank you very much for spending time to listen to this. I hope it was interesting. If this is your first time, please like, please share, please subscribe. Thank you and have a blessed day. Bye-bye.